Phyllis Schlafly, we're sorry. Hi, this is Scott Ott, and this is Bill Whittle now. And Bill, the Commonwealth of Virginia's House of Delegates and Senate approved the ratification of what would be the 28th Amendment to the U.S. Constitution, the so-called Equal Rights Amendment. The reason I mentioned Phyllis Schlafly is she was one of the primary campaigners against the so-called ERA in the 1970s. And Phyllis has passed on now and gone to be with Jesus. But we have a situation now where the courts will probably have to decide whether or not the Constitution gets amended again. I'll get into some details about that going forward. But Bill, this is exactly what the Democrats campaigned on in the Commonwealth of Virginia when they were running for office, saying that among their first acts, they would ratify the Equal Rights Amendment. In this day and age where cultural mores have changed so much and the relationship between the sexes is seen as much more equal already, why not throw them a bone and let them have this and move on?
Well, first of all, in the case of Virginia, they don't really need to add another amendment. They've already scratched out the second one. Why don't they just write the Equal Rights Amendment into where the second one used to be? The reason that this is not a good idea from my point of view is that I just don't see how it could possibly be defended as necessary. There was a time when something like this would have been necessary, in the same way that something like the 13th Amendment was necessary. And subsequent amendments prior to the Progressive Age. You basically an amendment to outlaw slavery, then you have to have an amendment to provide citizenship for former slaves and so on. If it turned out that women were still basically locked into either being school teachers or nurses, if they wanted to get out of the house at all, if they were getting paid different than men are, if any of that stuff was true, you'd have a case for it. But it's not. So you don't.
And I think the case could be made here that everything you said is true and that we've made a great deal of progress. But why not enshrine the accomplishment in the U.S. Constitution to send a signal to the world how serious we are about the equal rights of women, specifically because there are so many countries, including in the Muslim world, who treat women as if they are chattel or second-class citizens in the best of circumstances.
The reason to not do that is because the United States Constitution is not a billboard, and it's not a press release. It's not something that you go and stick things on so that you can get some airtime. And this is the entire argument. It's like, oh, well, yeah, you're right. Really don't need it, but it'd be great to show the rest of the world. That's not what it's there for. It's not what the Constitution's for. Every time you add a single word to the Constitution, you essentially make it worse. Now, some of those words are necessary. But again, if the Constitution had been written later or if slavery had been abolished before then, you wouldn't have had to add those amendments. Look, the Constitution is so well balanced in terms of how it's altered. It is possible to change the Constitution, but it's difficult, and that's how it should remain. And in order to make it something that can actually be passed, if you're going to actually pass this ERA, I think they have to make the case that this is something that needs to be done, and they can't make that case. I used to know what was the precise wording of the ERA, but there is nothing in it that I recall that was not already covered by current law, and I mean universal law. This idea that women get paid 72 cents on the dollar has been deflated so many times, but just for the sake of the argument, if you really think that these are the days where a woman can go in and apply at a Kmart for an assistant manager position, ask how much it pays, and then be told by the boss it pays $30,000 a year, but $26,500 for you, cupcake. If you actually think that those days still exist, then there's something wrong with you. You need to wake up. There's no reason for this. And since there's no reason for it, we shouldn't do it, because if we start tagging things onto here that aren't needed, then we further weaken the power of the Constitution, which is already under tremendous assault from all sides anyway.
Now, Bill, this is interesting. The ratification process of this is interesting because to ratify an amendment to the Constitution, you need to have a positive vote to ratify in 3/4 of the states. And so the 38th state would be, or forgive me, Virginia, Commonwealth would be essential to getting to that threshold. And in fact, the 27th Amendment to the Constitution, the one that requires that an election of representatives occur before they can raise their pay, in essence, so the people have a chance to vote upon whether they like the fact that the representatives are raising their pay. That actually took about 200 years to get ratified. But the difference is this. Somewhere along the line, amendments started to be written with provisions in them requiring a deadline for ratification. That particular amendment, which turned out to be our 27th Amendment, was originally written as the Second Amendment to the Constitution. That one didn't have a deadline. And so when a young man in Texas discovered that that had not expired yet, he launched a campaign and frankly, almost single-handedly was responsible for getting the 27th Amendment. It was an amazing
story.
Yeah.
And look, hold on one sec before, because I know that's just a setup, but just stop for a second. The reason that one guy was essentially able to change the Constitution was that I think everybody agreed that this was a really good idea. Certainly the politicians didn't think it was a good idea, but they couldn't be seen to say that. What empowered the 28th Amendment, 27th, sorry, 27th. Was the fact that it was so simple and it was so obviously a good idea that the entire country just fell behind it. There was a good reason to stop people in government from giving themselves a raise. And so that's why it was ratified so easily. And it didn't provide special protections for anybody or for politicians. It was a sensible, short, concise amendment. In other words, it's everything that the Equal Rights Amendment isn't.
Now, the difference between that amendment and the so-called Equal Rights Amendment is the fact that there was a deadline written into the text of the Equal Rights Amendment, and that deadline expired in 1979.
That's great.
Then Congress actually extended the deadline, and that deadline passed as well. And so the question for the courts to resolve right now is whether the fact that Virginia's finally come on board with this makes any difference whatsoever, since the deadline has long ago expired. It's a legal question, and oddly enough, in the constitutional recipe for the amending of the Constitution, the courts were really not intended to have a role, but in this case, they almost have to.
To ignore the fact that the amendment has expired is to basically say, we agree with some parts of this and other parts we don't. The part that we agree with will be law. The parts that we don't like won't be. It is essentially, if you are accepting the fact that you can continue this fight with this amendment after the expiration date, then you are essentially saying that expiration dates mean nothing, that nothing written down means anything, that there is no law, there is no possible way to make sense out of anything, because if we don't like what's written down someplace as a law, then we simply don't obey it. We just don't. And we're perilously close to this. So look, I'm a reasonable guy, and I believe that the Constitution can be amended when necessary, although it should be difficult. So have states already voted on the Equal Rights Amendment?
Yes. In fact, this was the 38th state to do so.
Well, no, it's not. It's not. Can we please stop this? Can we stop this, please?
Okay, it's the Commonwealth. Is that what you mean? You're upset?
No, it's not the Commonwealth nonsense. It's not. It's not. It is the first state to vote on it if they resubmit it with or without an expiration date. If the 37 states prior to it have already voted on it and the expiration date has passed, then those votes are null and void. That's what expiration date means. How hard is this?
To further complicate it, Bill, some of those states that originally ratified it, when their legislatures changed partisan hands, tried to rescind their ratification of the Equal Rights Amendment.
Which is why there's an expiration date on these things. This is you said, well, why not just let him have it? This is the kind of hill that I think I'm ready to go fight and die on, honestly. It's not because of my opposition to the Equal Rights Amendment, which is, it's not something I lose a lot of sleep over. I think it's just superfluous. But if you're telling me that the law is meaningless, if the entire purpose of amending the Constitution is to change the law, and inside of the amendment that we're talking about is a law that says it expires after this date, and we just plain ignore that, then what's to say we don't ignore everything else in the amendment and everything else in all of the other amendments and everything else in the Constitution? This kind of degradation, not just of law, but of the idea of law, is the entire progressive nirvana. That's their goal. The goal of the left is to be able to do whatever they want to, whenever they want. And if somebody else does something that they don't want them to do, then they want the power to make sure that they can't do it. That's why they have the kind of aversion to the Constitution that they have. You know, if you read this thing in the presence of progressives, their skin bursts into flames, and rightfully so, because it limits their ability to tell other people what to do. Now, if you had said to me that there was no time limit in the Equal Rights Amendment, we wouldn't be having this argument. Then we'd be having an argument about whether or not this is the right thing to do. But since, in terms of passing an amendment that had no sunset date on it, but since it does, the fact that this discussion's even going on is beyond my ability to really imagine. And if people who support the Equal Rights Amendment think this thing is so necessary, this is a very simple thing to do. You simply represent the amendment and you start off with a blank slate, because the votes that have already been cast on this have expired.
And in fact, Bill, that's what actually has happened. According to equalrightsamendment.org, Senator Robert Menendez, a Democrat from New Jersey, introduced March 27th, 2019, this amendment to the Constitution again. And I'm going to read to you the rather succinct language of it, but he introduced the proposal to amend the Constitution, and it was referred to committee after 2 readings. And here is what the article says. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. That's Section 1. Section 2, the Congress shall have the power to enforce by appropriate legislation the provisions of this article. And Section 3, this article shall take effect 2 years after the date of ratification. Now, there was also a version that was proposed in the House, and that Section 1 says women shall have equal rights in the United States and every place subject to its jurisdiction. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. And again, Congress shall have the power to put that into force, and it'll take effect 2 years after ratification. So there's a little bit of difference in the language, but that Section 1 basically says that there shouldn't be a law at the federal or state level that will abridge the rights of women. If they reintroduce that, which they have.
Equal protection? Do we not have an amendment that guarantees equal protection under the law?
It does.
So why don't we just use that?
So apparently they don't think it's adequate because it doesn't specifically say, and they would say, I believe that the subjugation and the oppression and the unfairness toward women has persisted despite the fact that since the late 1800s, we've had an amendment that guaranteed equal protection under the law. It doesn't specifically deal with sex.
First of all, that entire argument about women being suppressed in the marketplace and so on, you could have made that case in the 1950s. It's no longer true, but put that aside. The problem then is not that we need an equal rights amendment. The problem then is that the Eighth Amendment, was the Eighth Amendment, wasn't it? Equal protection? Did I get that wrong?
I'd have to go pull out my big book on the Constitution, but I think it's probably the 14th or 15th.
Oh, I'm sorry. In any event, yes, of course it is. It'd have to be after the Bill of Rights. In any event, then if it turns out that this injustice is in fact happening, and I don't think it is, but if it is, then there is already an amendment that guarantees equal protection under the law for every citizen of the United States. And that's what's not being enforced. You don't have to come up with a new amendment because, Scott, if you're saying this is the trap, and again, I just need to remind people because I know it's hard sometimes for them to realize your background, but Scott Ott wrote and delivered an amazing series on the Constitution back at the previous establishment called
Freedom's Charter.
Freedom's Charter, yes. I had it in my head a second ago.
And we're working right now, by the way, to get that out of the memory hole, but it currently doesn't exist.
That'd be nice. And it was basically all about not just about what's in the Constitution, but how it got there. And one of the single great debates, really, you could make the case, I think, was the salient debate about the Constitution, was the idea of the Bill of Rights, was the idea that we should not have a Bill of Rights because if we start to list the things that the government can't do, then they will assume that anything that we don't list, they can do. And that was a real danger. And that particular position is a strong position.
And beyond that, Bill, it even was a step further because if they started listing things that the government can't do, the fact that those things are mentioned in the Constitution at all would mean that those were matters about which the federal government is concerned and may have a say in.
Right. So basically what happened, if I understand it correctly, was the people who wanted the Bill of Rights in won the argument, but there was a bit of a compromise to the extent to saying, all right, we're not going to put it in the Constitution, but it's still going to be in the Constitution. And needless to say, the Bill of Rights is the first 10 amendments.
And frankly, the Federalists needed the votes. And the people who were opposing the ratification of the Constitution, many of them wanted a Bill of Rights included. And so in order to get the ratification vote passed, the Federalists essentially made the promise that in the first Congress, a Bill of Rights would be introduced and put up for ratification.
So that's politics. And that's politics. That's the good kind of politics. That's people with differing opinions finding a compromise that maybe one side is not as happy about as the other, but you can live with it. So again, any additional definitions degrade the protections, because if you're saying that women have to have a special amendment that guarantees them as women equal rights, then you simply will never end. You'll never run out of amendments.
Because fundamentally what you're saying is that's not a natural pre-existing right.
I want an amendment that protects male conservatives from being oppressed under the law, which is certainly the case in Hollywood. So let's chalk that amendment up. And then given the racial divide in this country caused by the left and the identity politics of this country, Scotty, if this happens, and if the justification for it is that women need a special amendment to the Constitution to make sure that the other law that protects them is enforced, then it's just a matter of time before we see the next 27 or 30 amendments protecting each one of the so-called genders that these people have cooked up. And we'll have to have an amendment for every one of those. We'll have to have an amendment for Asians. We'll have to have an amendment for Southeast Asians who might feel they're being treated differently than maybe mainland Chinese, and on 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 it goes. Ideally, and I think this was the spirit of the thing, otherwise I wouldn't feel so passionately about it. Ideally, the Constitution would have said it would have basically said all citizens rather than all men. And that would have been it. And then in terms of the slavery issue, you simply would have said, okay, they're citizens. They're not slaves anymore, they're citizens. They get the protections. And needless to say, that would have applied to women too. Look, the times were not ready for that. And the reason the Constitution can't be changed, and the reason I'm not one of these guys that say, don't ever touch it, ever, 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 is because societies do change. But in the case of the Equal Rights Amendment, it's something we should actually be proud of. And just the people who are doing this for the publicity sake of it, they know the truth. The fact of the matter is, there might have been, in fact, I don't think there might have been, there was definitely a case to be made for the Equal Rights Amendment in the 50s and maybe even into the 60s. You could even barely argue into the 70s. But what's nice about this, what's noble about this, is that in this case, society changed and did the right thing without having to have a constitutional amendment forcing them to do it.
Would you say, Bill, that even the people who were advocates back then, 60s and 70s, of an equal rights amendment, and the people who are advocates now, in a sense, you could credit them with perhaps nudging society along a little faster along that pathway, even though they didn't get what their ultimate objective was?
Sure, I have no problem with that whatsoever. Growing up, I remember discussions about the Equal Rights Amendment. I was not political until I was like 43 or something, so this was well before that. But yes, I remember discussions of the Equal Rights Amendment. I remember discussions about what used to be called women's lib. I remember, I remember the whole thing. And I remember the term male chauvinist pig. All of those things were resolved, and they were resolved not through the courts and not even through any real intent. I think it's fair to credit the original authors of the Equal Rights Amendment by making it clear to the American people that this was an injustice that needed to be addressed. But maybe it fixed itself faster than the amendment could catch up to it, or maybe it was something that just wasn't timed correctly. I don't know what the explanation is, but certainly it is not needed now. And not only would passing the Equal Rights Amendment, not only would that not help, but for the reasons I just outlined, would hurt the Constitution enormously, because you would then begin the process of demanding a constitutional amendment to protect your particular interest group. I think citizens is perfect if it were me. The language used to say all men are created equal. That was just, mankind and all of it. That's changed, and that's fine. That's appropriate. But if you had simply said citizens, or if you said citizens now, you would have a clear idea of what's actually at stake. Then people would have to argue against citizenship, which is what they're doing, needless to say. But then at least we'd know what the actual target is. And we should be I'd sum it up in a sentence. We should be proud of the fact that the Equal Rights Amendment is no longer needed in this country.
So how about Section 1? Equality of rights under the law shall not be denied or abridged by the United States or by any state. Period.
Sure.
Shouldn't be necessary. Think it's already in there. Bill, one final footnote
I'm
here.
I'm sure it is.
Yes.
Yeah.
Final footnote here. If this were an ordinary constitutional amendment procedure and everything had gone according to Hoyle, or at least according to Madison, then what you would have is, after that 38th state voted to ratify, the federal archivist would then gather up all those votes from the states, certify them, and publish them in the Federal Register. Right now, the federal archivist is a guy named David Ferriero. He's an Obama appointee. However, the National Archive has announced that they will be bound by the decision of the Justice Department in the Trump administration.
The Justice Department's ruling on whether or not the expiration date that has expired. Is that the ruling that we're talking about?
Apparently it is.
Oh, well, okay then. I'm glad.
Ladies and gentlemen, we are grateful that you have tuned in again and enjoyed another episode of Bill Whittle Now with Scott Ott. And we want you to know that even though right now we appear to be tiny little homunculus men who are just barely can, fit in a tiny little box on your screen,
or in your
we're
hand.
actually massive physical giants. And you can see
We're
us.
strapping lads.
That's right. You can see us in person on the Navigator of the Seas, a Royal Caribbean cruise ship, May 15th through the 18th, where we will be staging live productions of our shows at BillWhittle.com, as well as having informal conversations over dinner and drinks with people who are members and friends and fans of the show. So we encourage you to sign up for that. If you haven't done so yet, you can go to BillWhittle.com and find the link for that. If you don't obviously see it right away, go to BillWhittleCruise.com. We will provide a link in the description below, but we'd love to meet you in person, have a chance to hear your concerns, and frankly have...
And all those times you listened to one of these and thought, yeah, that's good, but he forgot to mention this. God, what is the matter with him? Well, you'll have a chance to get that out of your system and give me an education that I need. And I'm not being facetious here. I learned everything I learned from the people we've interacted with.
Do you think they'll have room for the massive scroll of things we forgot to mention?
Oh, the Great Scroll?
The scroll that will be unfurled of things we forgot to mention.
The Infinity Scroll.
That's
yes.
right.
Well, the problem is we can take the roll with us, but the parchment goes all the way back to Miami, and it just kind of unrolls as we go.
Well, ladies and gentlemen, we look forward to seeing you on that cruise. Make sure you click the link below to book your cabin today. For Bill Whittle, I'm Scott Ott. Thanks to the members for making this happen.